Action they can take. So if we take a 10-minute break now, and if that's okay, and then we'll crack on. Thanks very much. So if a duty is absolute, what does it mean? Right there. Section 2 of the Health and Safety at Work Act gives duties to the employer so far as is reasonably practicable. Give 3 of the things that, as an employer, we have to provide for our staff under Section 2. Who does the employer owe a duty to in Section 3? What duties do employees have in the Health and Safety at Work Act? So write down, I'm an employee, what duties do I have? And get a bonus mark if you can get the numbers. Number 5, can you remember any of the duties that manufacturers have? What should they do to meet their requirements of the Health and Safety at Work Act? And lastly, what type of notice must include details of the law that's been broken? Right, okay, so absolute, must or shall. So if it's an absolute duty, you've got to do it regardless. Okay, it's absolute. Section 2 of the Health and Safety at Work Act gives lots of duties to the employer. They've got to provide, so far as is reasonably practicable, a safe place of work, a safe working environment, training, information, instruction, supervision, a health and safety policy. No, ignore that one. That's not right. Ignore that. Health and safety, we'll come back to that one. Safe use of hazardous substances, safe plant and equipment, safe systems of work. So goals, it set us some goals, but hasn't told us exactly how to do it. Section 3, duty to others. Yeah, carry on.
Sorry, on number 2, I put toilets and hand washing facilities. Would that be classed?
It does require us to have welfare facilities, but it doesn't say what they are. So you're right in that. Yeah, so there is a duty to provide welfare facilities, but then we have regulations that then say, oh, toilets, hand washing, etc. But yeah, welfare facilities is right. Yeah.
Okay, thank you.
No problem. Okay, section 3, it's the duty to others. That could be your contractors, your visitors, those sorts of things. Employees, so bonus marks if you get the numbers. Section 7, it's our duty not to endanger ourselves or others by our acts or omissions, and a duty to cooperate. Section 8, it's the duty not to misuse and abuse anything provided in the interest of safety. Manufacturers have a duty to ensure that the article or substance is safe when correctly used, as far as is reasonably practicable, is provided with information on use and disposal, and they've carried out regular tests to make sure that it's safe. Just a few there. And lastly, both types of notice may include details of the law broken, but it's a improvement notice must. So an improvement notice must always say what law you've broken. Okay, you do see it on prohibition notices, but it's always must be on the improvement notice. Okay, so just done a little bit of a review of Health and Safety at Work Act. And if we just visualise the Health and Safety at Work Act and the statute law structure, we've got the Health and Safety at Work Act at the top. So that's setting these goals: safe place of work, safe working environment. Beneath it, we've got what are called regulations. And regulations are the law of the land, but they tend to deal with one or more specific aspect of health and safety. So as we are a member of Europe at the moment, and this law is still going to be in even if we leave, under the Health and Safety at Work Act, we've got a set of regulations called the Management of Health and Safety at Work regs, and these are the regulations that require suitable and sufficient risk assessment. So we'll be looking at those in another sort of session. So the management regs, as we tend to call them, they sit beneath the Health and Safety at Work Act and do a little bit more about how to manage health and safety. Then beneath that, you've got all other health and safety regulations. So we've got regulations on personal protective equipment, manual handling. COSH is the control of substances hazardous to health, like we've got here. We've got display screen equipment regs here, noise. Steve earlier on mentioned RIDDOR, that's a set of law about accidents. So all of those other regulations sit there, and these are all the law of the land. So if it's an act or a regulation, it's the law of the land. And we will be covering a few, some of you have covered a few more of those already. The management ones we'll be covering in a later session. So act and then regs. Then we've got something called an approved code of practice. And an approved code of practice, I've got here the control of substances hazardous to health regulations, and they're published with an approved code of practice. And an approved code of practice is, it's not the law, but it shows you how to comply. So when the law says do a suitable and sufficient risk assessment for hazardous chemicals, in COSH's case, The ACOP, the approved code of practice, shows us, well, how do you actually do it? So the law is the law, and it's not usually very user-friendly, but the approved code of practice takes the law and then puts it into everyday language. What can you do to comply? And if you follow an approved code of practice, you should then be complying with the law. Those of you who've got buildings, one of the approved code of practice that's very relevant is one called L8, because it deals with Legionella. It's attached to the COSH regulations, but with an approved code of practice, you've either got to follow it or you've got to do as good as or better. And likewise, if something goes wrong, regulations are the law, but approved codes of practice can be used in evidence in the court against you. So if there's a Legionella outbreak, they will prosecute under COSH, but they would quote the approved code of practice. And if the company wasn't following it, can you see it can be used in evidence against them? Guidance notes, also published by the Health and Safety Executive. So here I've got the display screen equipment regs, and it's the regs, but it's published with guidance. And guidance is just that. It's all good practical stuff, but you don't have to follow it. But it's good, you know. So if you see HSG, that always means Health and Safety Guidance Note. Okay, so published by the Health and Safety Executive, all good stuff, but can't be used in evidence against you. And the last one we'll finish off, we've got British, European, or even ISO standards. And British, European, and ISO standards are not the law, but they help us comply with the law. And particularly for things like equipment standards, you've got to comply with that standard to be able to put it on the market. So this is our structure. Everything gets its power from the Health and Safety at Work Act. And I would sort of compare this to a human body. The spine is the Health and Safety at Work Act. It's providing the structure. The management regs is the skeleton. And all the other regs and all the ACOPs and the guidance notes and the British standards, they're all the other organs that fit together. If you take the Health and Safety at Work Act away, you're also taking away the power of everything else. So the Health and Safety at Work Act actually allows all of those other things to actually work. If we took the Health and Safety at Work Act away, they would all collapse as well. So that's our structure. Okay, just finishing off this particular session, because I know this is one of the heaviest going one. Now, we have mentioned common law and statute law. They are sources of law. They're the law. We then have criminal and civil. And criminal and civil are the justice systems, the courts. Okay, so we've got common law and statute law are the law, criminal and civil are the courts. So our civil courts, they start at the bottom with the county court. So if someone is suing for compensation, the lowest court that they would go to would be the county court, and it depends on how much money they're after. After the county, they go to the High Court, the Court of Appeal, the Supreme Court, and as at this moment in time, we can still go to the Court of Justice in the European Union until we leave Europe. So on that side of the screen, we've got the civil courts. Now, in real life, the High Court is divided into different sections, as is the Court of Appeal and the Supreme Court. But for us, we're allowed to have a sort of simplified version. County Court first, High Court, Court of Appeal, Supreme Court. And that's all. That civil law is all about people getting compensation. The criminal side is the side that deals with breaches of statute law. So the Health and Safety Executive, if they prosecute somebody, the lowest court is the magistrates. Okay, so the case goes to the magistrates, and the magistrate will either hear it, or they will, if it's a very serious one, they will push it up to the Crown Court for judge and jury. But after the Crown Court, if there's an appeal, it goes to the High Court, Court of Appeal, the Supreme Court, and the Court of Justice in the European Union. Now, just to say, even being in Europe, if the criminal law is a piece of law which is UK only, the highest court is the Supreme Court. If it's something that's come from Europe, it can go to the European Court of Justice. So most of our law and the appeals tend to stop at the Supreme Court. The Supreme Court used to be called the House of Lords, but it was revised and changed a few years ago. So that's our structure. Prosecutions by the HSE and the Environmental Health Officer will go to the criminal side of things. Someone seeking compensation is going to go to the civil side of things. So if we put it into perspective, common law will tend to go to the civil courts. Statute law will tend to go to the criminal courts. The penalties are right nice and easy now. We used to have £5,000, £20,000 and different amounts, but if a case goes to the magistrates, they've now got quite extensive powers because they were updated in 2016. Even the magistrate can now impose an unlimited fine on an employer or an individual. At the magistrates, an individual can be sent to prison for 6 months, and at the Crown Court, it can be 2 years. This is just for offences under the Health and Safety at Work Act and its regulations, okay? There are other offences if it's corporate manslaughter, which we'll look at in a separate section. So when we mean employer, we are talking company. When we talk about employee, that could be an ordinary employee like you or me. It could equally be a managing director, okay? So the penalties are there if the courts want to use them, and these guidelines were established in 2016, and since then the overall amount of any fines has increased quite dramatically. So in our session, just to sort of bring us together, as I say, we'll do another little summary on the law front because there's quite a lot to it, but common law and statute law are sources of law. And the way I think of them, if you put them on the shelf behind you, they're the law. They govern what you do, but they stay there. But if you break one of those laws, if you breach common law, you can be taken to the civil justice system. If you breach statute law, you can be taken to the criminal justice system, okay? So that's how the system works. We'll do it a little bit more when we do our next sort of session, just which we're going to do slightly later in the course, just to have another look at the law. But a lot of safety people, a lot of health and safety people mix up common, statute, civil and criminal. So if you're not getting it all first time, don't worry. We're going to do another little session and hopefully the segments will fit into place. So thank you for participating today. What we've had a look at, the key underpinning knowledge, we've looked at some sections of the Health and Safety at Work Act, and basically the only ones that I've covered today are the ones that you need to be aware of. And if you do make a note, you've obviously got your notes when you're doing your assessment, use the numbers, okay? So use the numbers to show you know the individual sort of sections. Some of those are duties on the employer, some are duties on employees. We've looked at the enforcement officer powers and the functions and then the actions that they can take. We've looked at improvement and prohibition notices. And again, hopefully you haven't had any at work, but always you could pop to the HSE website, put in enforcement notice database, and you can sort of do a bit of a search and see what notices have been served, particularly if you're looking at customers and clients and contractors. We've had a look at the statute law structure, which starts with HASWA, goes management regs, ACOPS guidance. And we've had a brief look there at the court structure and the penalties. So we've broken the backbone of the law section. So thank you to particularly the people who did first session and this one. Sort of it's one of the more heavier going, and apologies, can't do too many exercises on this one, but we will be doing them on some of the others. So what to do now, apart from going and have a cup of coffee and go to the loo. So you've got your element 1 handouts. We still haven't done all of it, but we've done the common law, the statute law bits. So have a review of those. You've also got your separate key points handout, which summarises the underpinning knowledge. You can tick things off that we've done and that you're familiar with. But do have a look and find your end of element review, because you can start filling that in, because we've done quite a bit of element 1. And once we've done it all, then you can, when I say send it in, that could be the old fashioned using Royal Mail, who I used to work for, but you can scan it, email it in, etc. And again, if you send them in, we can mark them for you, and we'll also give you a marking scheme, but it's also just for your own purposes so that you can see that you're on track. Okay, so those end of element reviews, hopefully they're there. They're not just time wasters or anything like that, because if you can answer all those questions, you'll know that give or take, you're going to be where you need to be. You're going to have that underpinning knowledge that you're going to need for your end assessment.